See, I turned it on when I hit the gavel. Welcome to the Board of Appeals hearing on the LOSI application. I think it's called MD 0124. I will lay out what the rules of engagement are for the evening and what the schedule is going to be. And then we'll get started. We have two appellants and one applicant. We're going, since the burden of proof in a Board of Appeals hearing is on the appellants, we are going to let the appellants go first. They are each going to get 20 minutes to present their case. That will be done uninterrupted, no questions, no interference. The applicant, because there are two appellants facing the applicant, will get 30 minutes to make their case. At the end of that time, both the appellants will have 5 minutes to make a final rebuttal. At that point, we will open it up to the floor, and the floor will have, if anybody has any comments from the floor, the limit is 3 minutes. So we're not having any speechifying tonight, because we'd all like to get out of here before midnight. Questions and comments must come through me. I will recognize you and you will be able to speak. It's not a free-for-all tonight. We're going to keep it neat and tidy. Just before we get started, somewhere. So we are hearing appeals from planning board decisions on an appellate basis under Chapter 125 Land Use and Chapter 45 Development Review. The appeals board may reverse the planning board decision only if that decision is found to be, quote, contrary to specific provisions of the ordinance or contrary to the facts presented. So we are strictly reviewing whether or not the planning board followed the ordinance. I think that pretty much sums up how we're going to conduct this thing tonight. There's some housekeeping that we need to take care of as we move through here. We need to determine if there is a quorum present, and I believe there is for the Board of Appeals. We're all here, and I don't think we need to use alternates either. So we're all here. Has the appeal been filed within the required deadlines? The answer to that question is yes. And have the required notices for the meeting been given? And the answer to that question is yes. They've been posted online and in the newspaper and in various places on the island. The appeal has to do with the LOSI's application to create a subdivision up off of Marshall Cove Road, basically in part of the old Sunset Acres subdivision, which dates from the 60s and the 70s. Our jurisdiction is that this is under the planning board's Chapter 125 Land Use and Chapter 45 Development Review. We have the ability to hear appeals under both of those. And so that's why we're all here today. Does anyone on the Board of Appeals have a conflict of interest that they need to put on the record? I hear none, so we can move on from that. The next question is whether the appellant has standing to appeal, and in accordance with the Board of Appeals law, or Board of Appeals ordinance rather, pretty much anybody on the island has the ability to appeal a planning board decision, so that's not a big issue. I have explained the rules of engagement here in terms of sequence of presentations and how this is going to work. I am running the meeting, recognizing the board and public speakers. I will be entertaining motions and ruling on relevance of questions, et cetera, et cetera. All right. So I think we are ready to get started. Do we have to have a coin toss as to which appellant goes first? Who would like to go first, the Dexters or Seekman? You're here. Doesn't matter to me.
I'm happy to start.
Okay, great.
I have a timer.
You have
Stand
a
up
timer?
here. My name is Bill Kelly and I represent Dexter's. Oh, wow. We've got an hour. What happens when it runs out?
You'll find
The
out.
music comes up and plays you off.
Fireworks would be good.
Good evening, and as I said, I represent the Dexters, and I live both on the island and over in Belfast where my office is. I'm not going to go through in excruciating detail my materials because I'm assuming you've all had a chance to read them. And they are, of course, specific in terms of sections of the ordinance and law that apply. But I am going to try to point out a few issues in sort of the big picture perspective. And I don't think I'll take 20 minutes because you're going to have a long night. And again, please refer to my two materials, which are, of course, the brief I filed, as well as was a fairly detailed appeal application with the issues outlined on that as well. So the first point I would like you to think about is, where do you start with this process? And you start this process by looking at the findings of fact of the planning board. And as you are aware, that's a 7-page document. And the first 3 pages of it are sort of a summary of various things that happened during the process. And the next 3 pages, 4 pages are the findings of fact. And they're actually broken out if you look at the findings of fact very specifically. And for each of the criteria under chapter 45, there is an explanation of some evidence in the record, which is just some evidence in the record. And then there's the actual finding of fact. This is problematic, and I'm sure your counsel will advise you in terms of the way this record was created and the findings were created. There are only 2 forms of findings in all of the subsections. One says the standard's been met. Boom. No facts relied upon, it just says the standard should be met. The second finding is not applicable. So what will happen if you don't reverse or grant the application of the appellants is, when it gets to the Superior Court, it's going to come back down almost immediately. Because the record is not something that the court can review. There just aren't any findings of fact. Findings of fact are specific statements from the record as to what was relied upon to meet a given criteria. Findings of fact from the record that were relied upon to meet a given criteria. That had to be spelled out. None of that happened. So that's the big picture in terms of where do you start your analysis? It's with the findings of fact. I've outlined in my materials where I think those failed. The second sort of preliminary issue that is important that really sort of got run over by a truck at the planning board level is that there is a choke point, if I can show this, down here, which is about 100 feet of land from here to here, under the road, that's actually owned in fee by the Congdons and the Dexters, and that's referenced in your materials. That section of road is also depicted on the prior Sunset subdivision, and therefore the lots of the Sunset subdivision have the right to use that road. That's pretty much the ABCs of subdivision law. If a road is depicted on a plan, you get to drive over it if you have a lot in the subdivision. As the record reflects, there's a major flaw in the approval from the planning board, and that is this. This area here for lot 4, and essentially, if you include the Jerry Jones property as well. This, as you know, is what was referenced in my materials as the Joan Corby lot, because that's where it came from. In the record of the deeds and the chains of title. The planning board failed to consider as a jurisdictional issue before they got going that you can't approve a subdivision unless the applicant demonstrates that they own the land and they have the right to get out. It's basic. Can you imagine if anybody could file an application for a subdivision and not own the land? No. Access over a right of way is just as important. So the planning board cannot exercise jurisdiction. It simply says, we're not hearing the matter. You can't prove that you have the right to get to the majority, about 20 acres or so, of lot 4. You can't be clever and cut a little piece of lot 4 on the old subdivision and say, I have access to everything. Can you imagine that if there was 150 acres at the end of the Sunset Acres subdivision road, where the Joan Corby parcel is, and somebody included 50 feet of what was the Sunset Acres subdivision, and then they said, now this other 100 acres we're going to access, and we're going to get over the Sunset Acre Road. Well, you can't do that. Now, eventually, if this has to happen, of course, there are private rights that can be exercised in a different court action in terms of stopping people who own lot 4 from going over the section of the road that's owned by Dexter and Comden. And the record was very clear about that. This is also a failure of the applicant to show what's called a legally cognizable interest. Anytime a board exercises jurisdiction to review a permit under a subdivision ordinance or site plan ordinance, the applicant has to show that there's some right that they have. It could be a contract to buy it, could be easement rights, they're quite substantial, could be real property rights, meaning they own it like you own your home, the fee interest. That's how you get in the door, that's how you get your ticket to go through the planning board. And this is not a theoretical thing, there's a case I referenced in my materials called Tomasino. And that's exactly what the planning board failed to do and then was reversed by a Board of Appeals. And in that case, it was, the court said, you should have looked at the deed on the easement here. Because the language in the easement is not sufficient, they actually had an easement. And that, yes, it is appropriate for a planning board to look at the nature of the interest that they're claiming to be right title and interest. And your ordinance, as you just described, we're here to talk about the ordinance, does require people to demonstrate right title or interest. Pretty basic idea. The suggestion in the materials that were filed by the applicant is that's an issue for the Superior Court. Well, that's not true. We're going to have a charade that goes on for a year or two because somebody just files an application for a subdivision permit. They go through with it, and then only the Superior Court sends it back because they didn't actually demonstrate that they have right title or interest to access the property in question. So I want to carve that out as a jurisdictional issue that the planning board should have looked at to give the Losi's the ticket to play. Shouldn't have happened. There's a sub-issue involved, which was described carefully also to the planning board, which is this. Aside from the jurisdictional issue, when you have a choke point, or I should say subdivision road, and somebody wants to hop on those rights for land that was not in the subdivision, that's called either a surcharge or an overburden. We can all get that concept. Why do you think you get to have the extra 20, 30, 50, 100 acres outside of the subdivision, suddenly enjoy the rights to go over a subdivision road when you don't have them? And the answer is you can't. So that is a title issue, and it is a more substantive review and by the planning board. That's not a jurisdictional issue, but it was clearly presented as a problem. And they just didn't address that at all in their findings of fact. This is the first time I've ever seen a subdivision, and maybe you guys have seen these before, come before you. It's the first time I've ever seen a subdivision where they didn't demonstrate how to get to a public road. Marshall Cove Road is a private road. There's no right of access for the most of lot 4 over the Marshall Cove Road. And there's no right of access over the Trim Lane. Instead, there's this sort of in the middle of nowhere in a sense that it doesn't actually relate to a public road. And of course, you do have to get to a public road under your ordinance. There's a fatal flaw in lot number 3. And I mentioned this in my materials. Lot number 3 has this thing called a 50-foot right of way that for some reason goes all the way down to here. What is that? It's not a road as required by the subdivision ordinance. Because in order to have frontage on a road, it has to be along a boundary. Now, if you looked at the old, I'm sure you have, the old Sunset Acres subdivision, it's a road that goes down through the subdivision in this area, and land is conveyed abutting the road. In this case, the road is within lot 3. There is no road. It's essentially a driveway over lot 3. Lot 3 does not have any frontage on a 50-foot wide right of way. It has it within it. And as I mentioned in my materials, it's very clear if you look at the definitions, they needed to have frontage on a road. Lot 2, as I mentioned in my application, has the same problem. They do not have frontage on a road. Their frontage on lot 3, which has a driveway running through it. But that's not frontage. There's a reason, of course, because the road has to stand alone, has to be improved, and has to have, and it provides access to all the other lot owners. The other issue that is of concern is why in the world is this road extended down into here? What in the ordinance allows for that or provides for that? And of course, nothing does. I don't know quite how to infer what the purpose of this was. But it certainly appears to me that it was to demonstrate for future people who look at this approved subdivision that somehow the Jones lot has legal access out, and it doesn't. There's no evidence of that in the record. So that shouldn't have happened either. Those are my main issues about access and the road, and they sort of speak for themselves. One of the stranger things that happened here is what was the old Sunset Acre subdivision has now had its lots reconfigured. And the Congdon materials describe that, and I described it as well. And you can't do that. You can't come up with a subdivision that amends an old subdivision unless all the lot owners who are lot owners in the old subdivision agree. They bought land based on a subdivision, based on a demonstration of how that subdivision was laid out, and they get to rely on it. Imagine if you bought land in a subdivision and suddenly all the lots were changed, or the lot lines were moved, or the road was moved, and you didn't agree to it. It becomes the law of the property when a subdivision is recorded in the registry in terms of the configuration. Clearly, folks do not agree with that as it's in the record. So the layout issues are quite a few that I just want to highlight. One of the things that is in the findings is a reference to the fact that all other ordinance requirements in town must be met for this project to be approved. And unfortunately, or fortunately, however you look at it, Chapter 125, the performance standards, none of that was reviewed. And it makes clear, as I say in my materials, that it had to be reviewed. I don't know why it wasn't reviewed, but it wasn't even considered. So all of the findings of fact that should have been done for the review criteria in 125 were not applied at all. And finally, on the big picture is, you can't approve a subdivision and properly review all the review criteria unless you know what's going on there. It's the subdivision ordinance isn't written in such a way that you can just divide land and tell everybody later what you're going to use it for. You've got to identify that. You've got to identify and then use the criteria and the ordinance to review the impacts for all the things that the ordinance requires. Erosion, emergency access, water quality, where our house is going to go, building envelopes, setbacks. You can't just have a statement on the survey plan that says the setbacks will be met. You have to demonstrate that. So you know what's going on and you know how it's going to be developed. That's a pretty big issue. And I don't know how you get around that. I've never seen a subdivision before that did not actually identify the uses. So the review criteria could be actively applied to the proposed use. There is a section in the application that says check a box. None was checked. It says that the property had previously been used for residential purposes. If that's the case, this was going to be residential, then it should have been reviewed. There are test pits which suggest that there's something going on in the future, but I don't know if they're 3,000 square foot houses or 15,000 square foot houses. You don't know. So that's a flaw as well. But those are my main issues to try to have in your head as you go through this process. But my materials, I don't usually do the great list of things in terms of making an appeal before a board, as my written materials do. I think 13 in the application and 5 categories in my brief. But I felt I had to in this case to really flesh out the full picture of what went wrong. Those are my comments that I'd like you to keep hold of as you go through this. Thank you.
Thanks. Okay. Do we have any questions from the board at this point? All right.
Not yet.
All right. Seekman, you're up. 20 minutes.
Gotta get there quick, cause that sand running on that bottle. I'm Terry Cowan. I'm representing my partner, Kara Seekman, who is an owner of what in Sunset Acres was lot 7. It is the lot. Kind of kitty corner here between lot 1 and lot 3. This is, actually, she has 2 separate lots, a smaller 2-acre lot right here. A larger, about 5 acres here. They're all in the same ownership, but they are separate lots, at least they have been. And Bill Kelly, as I suspected would be the case, has stolen a lot of my thunder, and I thank him for that. One thing I did want to do that might help the board is distribute, if I may, with the permission of the chair, put out a little collection of smaller scale, you want to take them up? Smaller scale maps that are just a map of
References.
Sunset Acres
Make it easier. to
as
understand.
originally permitted. A map of a plan that was drawn by Jesse Rollerson.
Is this in the?
That's what I'm
record?
looking at right
It's
now.
all in the record.
Just so wait until I can.
Okay. Confusion this may have caused. Basically, I think at a ball game, you really can't understand what's going on without having a program. And this is kind of a program that is neutral, not partisan, but just map plans that people submitted. One of the things that's interesting, I would just say right off the bat, is the map up there that is submitted as, I guess, the final plan for Mr. Ossie. My understanding is that that is a plan, though it was signed. It was returned from the registry because it had colors on it, and registry will only accept black and white prints. So there is a different final plan, the plan that was signed by the applicants, I'm sorry, by the board members, and registered in the registry on, I think, January 21st or 28th or something. That I have a smaller copy of what in fact is the correct plan. This is a
This is a
previous
draft,
plan.
this is a draft because it shows a lot 4.
Yeah, that too. That's the next problem.
Well, this is a draft. This is not the final plan.
Okay, I thought I saw the signature on the surveyor and so forth. And are there signatures on it? No, they're not. My eyes. Okay. I think that what I wish to do is perhaps even be quicker and more succinct than Mr. Kelly. He has spoken of in much more persuasive legal terms the issues that I, or more particularly that Kara has. But what I would like to focus on is a couple of just sort of general issues that are in the record, particularly in terms of a series of letters that I submitted to the planning board. And I would say almost as an aside, that though I submitted them timely, they were never even officially considered by the board itself. So they were just kind of floating out there. But I use letters rather than speaking publicly as a way of just saying what I thought the issues were, perhaps as a way of clarifying what was going on. I still think those letters are useful and informative, and they are part of the record. But what I really want to focus on is what happened to Kara's land in the process that Kara has gone through for the past, I don't know, 6-7 months or so. This has been before the planning board. And there have been some fairly serious disputes and some fairly serious arguments. And And we're now to this point. I think it's unfortunate that Kara and I and Mr. Losi in particular, but also Joan, were friendly, if not close friends. We gave to Mr. Losi our permission to cross and crisscross Kara's land. Use the surveyors wherever he wanted to go to survey pins. We gave them ideas and information that Kara in particular had about her land and where bounds were and meets were. And everything was very cooperative, I think, at the outset. And it has just gone south on us over time because both Mr. Losi and the board, the planning board, has not been able to accept our definition of the issues, those issues that Mr. Kelly talked about in part. So we've had this kind of parting ways, and it's been unfortunate. I think if the planning board in particular had been more responsive to abutter concerns and issues and questions, things might have gone a little bit more smoothly for all of us. I don't think I need to brief the new board on the rules of the board. I think the chair did that. And I don't think I really need to speak about the rules of the planning board and planning board procedures, but for one thing. And that one thing is that the planning board is a very peculiar board, and it is statewide. It cannot, how do I put this? It can't find wiggle room. It can't sort of say, well, yeah, we like that, but we don't like that. And we kind of would like to permit it, but we don't want to because there's a problem. Planning board has to make decisions, up or down, yes or no. You're right or you're wrong. They have to make definitive, firm decisions, and they can't wobble a little bit. As an example, Mr. Kelly was talking about the findings of right, or findings of rights.
Fact.
Huh?
Fact.
Facts, findings of fact, thank you. And I had a lot of problems with the findings of fact that the board filed. You have copies of it. The biggest problem is that the board just waived its authority, waived its interest, waived its duties on 8 of those 13 findings of fact. They said either something was not applicable or something was not relevant, or there was a third phrase there. They just passed. They didn't find any fact on 8 of the 13 issues that were before the board. And I just think that's very unfortunate, and it's also just a dereliction of the board's duties. And I think that sort of not being interested in solving the problem carries over into the antipathy that did develop during the hearings, because there was not real leadership, focus, something on the board, and the board was not particularly interested, I would say, this is just an opinion, but was not particularly interested in listening to the abutters and listening to sort of neighborhood concerns and neighborhood conditions. And that's kind of what I want to talk about in my remaining sand. What happened to Kara's land in the Losi application? First thing that happened is that originally in the 1970s, there was a subdivision. Sunset Acres, you have a small copy of that subdivision. And Kara and her then husband bought there, then called Lot 7 in the early 90s. But in the 1980s, early in the 1980s, when Mr. Losi and Joan were getting ready to buy their 2 properties, lots 5 and 6, there was a concern about what their access was going to be and so forth. And somebody, I don't know who, hired a known surveyor of repute on the island, Jesse Rollerson, and had him draw a plan. And he drew that plan, and you guys have it with you, in front of you, that showed that what's referred to in almost all the paper that you have is the Lot 7 road, which ran all the way through here to this point. This was the Lot 7 road, and that's how it's referred to. And it was 3 members of the board of selectmen who were sitting as the planning board in 1985. They sat because the planning board was just getting organized and they had the authority to act in their stead. They decided that there's information from whoever hired Jesse Rollerson, I guess, and maybe from the Losseys, also concerned from the Losseys, that the real right of way, the way that people traveled, either this way or this way, that real right of way was here rather than here. And they decided that the right of way was did not have a significant impact on land use and land ownership and so forth. And in fact, a right of way is something that almost floats over the land. You drive on it, you walk across it, but you do not own it. The owner of that land, either side of the right of way and underneath the right of way, he's the owner, she's the owner. And consequently, as long as you're providing a way to get from point A to point B across your land, you can give somebody a right of way, they can cross your land pretty much however they choose or however much they are following an existing right of way. And that was the deal with the right of way, so-called along lot 7. And the acting planning board at the time, 3 members, said that without doing any significant research, without advertising any public meetings or hearing from the butters or anything else, they said, yeah, the real right of way is that curving kind of C section across what at that point was lot 5 and 6. And we want to move the right of way, we're going to move the right of way just by fiat, they could do that over to where it in fact really is. They were sort of correcting a mistake of how the right of way was drawn. So they moved it. Jesse Rollerson plan, however, also got rid of the proposed road, which was a 50-foot road, which was still here. They didn't move that road. They just moved the right of way. There were other details of that Jesse Rollerson plan, which were not specific to changes of the subdivision, of the Sunset Acre subdivision, but they were interesting, I would say. The Rollerson plan said that this right of way shown to the shore, which is supposed to be, and on most deeds, is a 50-foot right of way down to the water, which is significant because now it is part of a marine activity zone, which runs for 250 feet up from mean high up to almost what's called the intersecting road there. And there were other changes, but specifically what they did is they got rid of the road. I mean, they did not get rid of the road. They left it where it was. They just changed the right of way. And what was most interesting about that is that this right of way, A, from here to here, and actually from here to here, was important frontage for Cara and for her 2 lots. She had frontage from here to here on what was a proposed road. Interestingly, the Losseys also, for what were lots 5 and 6, 6 being here, 5 being here, this whole of lot 1 was actually 2 lots that were sort of divided this way. This lot 2 had, lot 5 had 200 feet of frontage. This had 300 and something, or maybe more frontage. When the Rollerson plan was submitted, it showed that this road was gone, and by implication, at least, the frontage was here along Trim Lane, along with the right of the way. In fact, the frontage still was here because the road wasn't moved. 2 months after the Rollerson plan was accepted and went to the registry and so forth, 2 months after, instead of in January, in March is when the Losseys bought their 2 lots, when they closed on their 2 lots. And what's most interesting, they used as the easternmost boundary of these 2 lots, also this side or the western side of the still existing proposed road. That was their frontage. The Rollerson map, I guess by implication pretty much had to assume that the frontage was here, but it never got moved. So that was the first issue that Cara was concerned about, is catching up on her are not losing really her, yeah,
Can I add one thing?
huh?
Can I add one important thing?
Sure.
The lot that I purchased first was the 5.5 acres that's landlocked. My frontage is this right of way in question. So I have a landlocked piece of land. My frontage is that right of way.
Mhm.
And if you look at the final page in your packet, that is today's town tax assessor map. They did go with a Jesse Rollinson plan for about 3 or 4 years, but they have, because I lose my frontage, they have reverted in our town map back to the right of way, because otherwise I don't have frontage. And I'm not allowed to be harmed by development. And we need to stick to our original rights of way and our land values. I'm not allowed to be harmed that way.
Thanks.
Yeah.
Yeah, the other thing, the point is that Tara has been struggling for 6, 7, 8 months, trying to claim that in fact this is still a proposed road. It may have been abandoned. If it has been abandoned, then she and Mr. Losi would each own half of that, but that has never happened. It's still a proposed road. The other issue that Kara had was that the Losi plan, you have to use your eyes and be careful here. The Losi plan shows a 25-foot right of way on her property, this 25-foot strip. From here's the boundary between lot 7 and lot, I think this was 6 on Sunset Acres. I'm not sure the number, but this was a Sunset Acres lot. And that was the boundary. And there was a right of way across. Actually, this right of way was specifically for the exclusive use of the owner of what's now called Camp Conundrum. It was the Olsons, and then the Olson families, and so forth. There's now a LLC and it's Camp Conundrum, but it's all the Olson family. And they were given by the developers of Sunset Acre an exclusive right of way to get from there to their property right here. In 1980s, the owners of this lot,
87, the Congdons.
huh?
87, the Congdons.
Yeah, they had a common right to, but the point is that this plan shows, if you look carefully, that the Siegman lot boundary here ends at this bound and then skips over to this bound and goes that way. So this is open. This land was by plan open to the Olsons. It was their property. I saw an earlier plan, you don't have it in the record, but I saw an earlier plan that was nicely colored up. That was colored up with the same colors as the boundary of Camp Conundrum. So Kara not only lost her frontage here, she also lost by plan her ownership of 25 feet that runs the entire length of her property, and an ownership of what also was, because this was a right of way, or at least arguably it was frontage on this lot also, if it became necessary to use her. It was a possibility. So she lost the land and the potential of owning land. And I think the sand and the clock is telling me it's time. Kara wants to talk.
Yeah,
No,
I did not lose my back lane. I posted for 6 days against adverse possession. The Losis do not have a right to cross my land. Only Julia Olson has exclusive right of way across my land. She hasn't owned it for 40 years, but I did notice all of my neighbors and I posted for 6 days, so it is my land. He's not allowed to take away what is on my deed, what I only have given exact wording on my deed and Julia Olson's exclusive right of way. So when Mr. Losi asked to walk across my land, I welcome him. He's able to ask, and Joan too, if she'd like, but they do not own my land. That's my land.
The other thing I want to add, is that if in fact Kara lost by the actions of Mr. Losi and of his surveyor, she lost her access here. She is harmed by this plan, by what seems to be a taking by Mr. Losi, a taking rather that shows his property line as being on the western side of what is supposedly lost, while Kara's on the east. And more importantly, she did have frontage and it's gone. And I think in conclusion, all I'd like to say is that if Mr. Losi is going to claim, and he's made several attempts to claim that this right of way is a road and he owns that road, if in fact he does own that road, then Kara's frontage really has moved from here up to here. She has frontage on Trim Lane, and if Mr. Losi would like to reestablish her frontage and expand her frontage so she generally has frontage on that road, now that would be fine. We would be happy to do that. She would be happy to do that, but I don't think that's gonna happen. So I'm gonna just wrap up and say that that is it. Too fast, too much information, but Kara was harmed by both actions, those plans, both of which are reflected on the plan. But happy to take questions.
No, we're
That's
not,
it.
we're not doing questions. I mean, unless anyone has specific questions from the board.
No.
Up to this point, okay. So
Thank you.
we're ready for 30 minutes for the LoSI presentation.
Okay, my name is David Perkins. I'm a LoSi's attorney, so I'm gonna start, and then David is going to present as well. Just as a way of background, I'm from Lincolnville. Last night I took the 5 o'clock ferry out to come to your meeting. All the guys in the ferry said, do you need a ride somewhere? But luckily, these guys were here last night, so I got to sleep on the couch.
Welcome to Island Life.
You've had plenty of time to prepare now.
So if I look tired, that's the reason. We have a very different perspective on the planning board and its functioning. I wasn't at any of the planning board meetings, but I've looked at the record as you have, and I've talked to the LoSi's. And I see a planning board that was very deliberate, had multiple hearings, got input from their attorneys throughout the proceeding, and came up with some, I think, good solutions to solve some issues. When the LoSi's first applied, they were asking for approval for lot 1 is already their house. And lot 1 is the lot that's in the Sunset subdivision. So they show that on their plan. Lot 2 and lot 3, they were gonna leave lot 4 out because the neighbors had always made noises that lot 4 didn't have access. So they just tried to simplify things. They weren't trying to upset neighbors. They're trying to get these 2 lots recognized. The LoSi's bought 3 parcels over time. So this land was originally 3 parcels. The ultimate outcome here is 3 parcels. And that happened with the guidance of the planning board. Although the LoSi's first came with lot 4 not included in their subdivision, the planning board said, we want it all included. We want all your land included. So they put that in. And to speed ahead, when people started talking about the title right and interest issue, do you have access? Nobody was disputing that lot 1, 2, and 3 have access, and I'll explain that. But nobody was challenging that effectively. And let me say something about challenging something. You can't just come in and make arguments to the planning board to say, they don't have title. That doesn't cut it. You have to put in deeds, you have to put in title opinions, you have to put in survey, you have to put in something real. And there was none of that here, just a lot of noise about there's no easements. What the board's council ultimately recommended was to make lot 4 and lot 3 one lot, because there was no dispute that this had access. And that was the plan, as I understand it, that was the planning board's way of an elegant solution to not have to deal with the issue of whether this part of the parcel didn't have access. But Attorney Kelly, I don't think has read the record as closely as maybe he should have, because when this issue came up, gave us the Corby to Chase deed. And that granted right of way to the town road. And under Maine law, once a parcel has an easement, if you neglect to repeat that next time you give a deed, and I have the statute here with me, which I will give to you, that parcel still has that easement. So what does right title and interest require the Losey's to do? We're not doing what Bill Kelly claimed, that we're saying, oh, you just have to go to court to litigate it. That's not what has been said, and that's not the case law. The point is, the planning board is not charged with litigating it. The planning board is a gatekeeper, and they have to be satisfied that the Losey's have the right to use these lots, these 3 lots, in the way that they're proposing, to break them up into lots. Someday they're obviously gonna be camps or houses. And they presented their deeds, they presented their survey, and they presented the express deeds that had the easements. Nobody responded by putting something of a legal nature in front of the planning board to say there's no easements. I mean, everybody waved their hands and said there's no easements, but nobody demonstrated that in the way that the planning board has to respect. And so in the end, the question for you is, when the applicant comes, has a survey, responds, provides the deeds that show the historic access, and it's clear that this Trim Lane, Marshall Cove Road had been used for many years, the planning board's entitled to say, okay, there's enough standing, because all this is about, it's not about proving what you have or what you don't have, but it's not standing to proceed with your application. And that's what happened here, and it was the right thing for the board to do. Let's talk about the standard of review tonight, because I think you are getting this, but there's a lot of facts being thrown around here tonight, and those facts don't matter. What matters is the record. So people who don't want this project to happen can't come in with new facts, new arguments. They have to point to the record, point to things that they put into the record and presented to the planning board, and that's really not happening here tonight so far. So the review is limited to the record, no new evidence, and the appellants bear the burden of the proof. So they have to show that the planning board made a mistake. The folks that just spoke are really, we're very respectful of the issues they have about what's happening up here, but that's not really what this is all about. These are the boundaries that the surveyor set. If there's something else going on up there that they think affects them or doesn't affect them, that's fine, but it doesn't affect whether the Losey's are entitled to take the 3 lots that they received over time and to have them approved by the planning board for 3 lots once again. So the board did consider TRI and they got it right. The issue of Attorney Kelly raised the issue about whether there was a surcharge or an overburden on Trim Lane and Marshall Cove Road, and he said, "Oh, we have a choke point up here." That's a nice thing for your neighbors to say. We have a choke point up here of 100 feet, but that choke point, I mean, property is layers of rights, right? It's not like a unitary thing. And if they own 100 feet, but if there's a historic easement across there, that doesn't stop people from using that. And the fact that what was historically 3 lots is now going to become 3 lots again, and there's going to be you know, of ultimately three homes using that road, that, there's no evidence that that's overcharging it, or, you know, that's gonna cause the road to fall apart or whatever, and I think the planning board had good reason to not find that this very modest subdivision was gonna be an overboard burden. He raised the issue about, oh, this is really changing the Sunset subdivision, and it's not. I mean, it's a little bit odd that, you know, this lot right here was 5 and 6, or is 5 and 6 in the historic subdivision. And it still is in the subdivision. The Losey's have always owned land to this side, next to their subdivision lot. You know, so the fact that they now are breaking this up, the Sunset subdivision is what it's always been, and they're still part of it. These lots are not part of it. And then the question was, the argument by Mr. Kelly that, the board erred because it said, the board accepted the fact that Dave Losey said, I want to get these property lines approved for lots. And we'll leave to, the planning board to deal with future owners of those lots when they know what they want to do with them, to come back to the planning board to get approvals for doing those things. And I wasn't there, and Dave can talk more about this, but my understanding is that the planning board accepted that they were focused on approving the lots and dealing with whoever bought the lots, their house plans in the future. They did do some waiver of things. There's arguments made that you had to have fire hydrants and you had to show technical capacity, and they appropriately waived those because Mr. Losey wasn't coming in to say, I want to build houses, or, you know, he didn't have a plan. He wanted to take the 3 lots that is merged, and you probably understand this, but you can buy 3 lots. If they touch each other, it becomes 1 lot. So if in day 1, he bought those 3 lots in 3 different names, he wouldn't have to be here. But he didn't. He allowed them to all merge. And really what this was all about was going back to get 3 separate lots. And the planning board worked with him to say, we're not going to make you, you know, do geotechnic and for things that, you know, if you don't have a plan yet, that will be deferred. Dave, I'll pass it on to you.
Good evening, I'm Dave Losey. The poor beleaguered landowner is trying to get 3 lots out of our 50 acres. Couple of things. First of all, you look at the old subdivision, Sunset Acres subdivision that we bought into, it didn't have all the details of the setbacks and all that kind of stuff. When we built our house, we came to the planning board and said, this is what we would like to do, and we went through everything that they asked us to do. So, that's what I thought the rules were here. We had lot 5 and lot 6, wanted to add a little bit of your adjacent land to it, so we made it a better lot. I mean, it was really just that simple. The issue of this trim lane relocation, let's talk about that for a minute. Back in 1980, I don't know, 4 or 5, when we bought this land, our lawyer came to us and said, the road's in the wrong place. Well, okay, what do we do about that? Let me go to work on it. So he thought that,
So the road was existing?
no. Well, yes, the road was existing in the configuration shown
Right.
here. And he said, wait a minute, the subdivision plat shows it coming a straight line across here. No, there's good reason for that. Go out and have a look, like the planning board did. There's a very steep ledgy area here. Putting a road through there is, I'm sure, possible. But it just doesn't make any sense. By coming down into the more usable part of the land that we bought, you get a nice road. So they did. common sense. So our lawyer, went to a guy named John Carver, no longer here, but he went to the planning board. Maybe it was the board of selectmen acting as a planning board then, I don't know, it wasn't of interest to me, but he went to a board and got this loop road approved as part of the subdivision. So that, it became, so that was our access for our two lots. And so it has been from the beginning of time. With regard to the lot, the lot line on Seekman, I don't know. I don't know whether it's supposed to be that side of the unbuilt proposed road or the other side of the middle. That's why I hired a surveyor. I asked him, you figure it out, please. Find the pins, find the history, do it. You're a surveyor. I'm just, the guy who's hiring you. That's what he concluded. And so I wasn't, at a planning board meeting, I was accused of taking land, and taking anybody's land. I'm doing what the surveyor told me. And with regard to this lot 4 business down here, the left of Corby, I knew there was a squawk about it. I also knew that the deed existed, which said when the line of Corby came right through here, and this was all Corby. When they sold to Shays, a deal was made with Ellis, Grinnell, and Randlett, who did the subdivision, to bring Trim Lane up to service the Corby property. The Corby property was all of this at that time. They later sold to Shays, and as Dave Perkins told you, there's a statute that says they don't lose their access because of that sale. So I knew this, but I didn't want to go to war over this property at this time. I just wanted to get 3 lots created without touching this Corby land. The planning board asked me, no, we don't want that extra land out there. We want it resolved, so please create a 4th lot. So I had the surveyor come back up, do all the pins, get the soils tested, all that kind of stuff, and we created a 4th lot. The access issue still came up. And the planning board's attorney suggested combining 3 and 4, because 3 obviously has access. I said, fine, let's do it. I came for 3, I end up with 3. Let's cut it out, for heaven's sakes. We own all this land, we could cut out a piece without going through subdivision. Right? And then 5 years later, do it again. In 1971, I went before a planning board for the first time. I was just out of law school. And I learned a lot from the planning board. One of the things I learned is that these guys know what they're doing. They've been through a lot of these. And I thought that by going through the process here, I would learn what maybe I didn't know or what I hadn't thought of. So I wanted to go through that process. I'm now consuming, I think, eight nights of the planning board's time and now a night of your time. And sometimes I just wonder if it made sense. But I thought that this participation with the town officials was the right thing to do, and I'm still trying to do it. But that's why, that's the history of the combination of these lots. And with regard to fire hydrants and sidewalks, when I see them elsewhere, and I put them in over here. But I mean, I think there's some things that if you were to build a condo community someplace, a fancy modern thing, yeah, you'd want to do this kind of stuff. But we're talking about a dirt road with some houses on it, like we've got all over Maine. And let's use common sense. I think the planning board did a good job of applying common sense. Does it make sense to force a road through a slopey, ledgy thing that's virtually impossible? Hardly can walk up there. Of course, it doesn't make sense. So let it go where the road should go. I'm asking you to sustain to reject these appeals and recognize that the planning board did a really good job. Perfect? Probably not. I haven't done anything perfect recently. But they did a really good job, and I think that their efforts should be honored. Thank you.
Here with like 5 minutes to go to the bath. Put the clock on.
Yeah, that's right. And when I come back, we will have 5 minutes for rebuttal time from Dexter and Sheikman. So amuse yourselves. It's full. We're back. We have 5 minutes of rebuttal time for Mr. Kelly and for the Seekmans. Who wants to go first on this?
We discussed, and I'll be going first.
All right, start the clock.
First of all, thank you all for being here. It's really generous. I know it's volunteer time for many and myself included. But I really appreciate it, and lots of good brains in here. I know you all will come to the right decision. So I'd like to just, in chronological order, which is how the pack of materials we share with you, this is the original, or actually also a revised Sunset Acre plan. There was one previous which I could not dig out of the registry. So this is the best we have going back to 1978-79. The pink boundary is all of the original lots within Sunset Acres subdivision. With that ownership, we have rights to use all of the roads within that boundary. So right of ways stand to this day. Subdivision rights of way do not go away. They're forever. We also have the right to keep the bounds of the lots the same. So to this day, there must be a re-subdivision which involves all of the owners of the subdivision agreeing and all of the abutters of the subdivision being invited to the hearings. That did not happen. So this is our original bounds, and the famous Jesse Rollerson plan you all have a copy of. When you read the not such fine print, is very clearly an amendment to the subdivision. It is not a re-subdivision. A re-subdivision might be able to move the lot lines, but an amendment cannot move the lot lines. Therefore, the land is still here with my frontage. And that has been returned to the tax map. After briefly going to this version, they came back to my frontage. The next part that's very important is when I first purchased my land, I bought 5.5 acres. If you can see it most clearly on the current map. I have 5.5 acres and I have 2 acres. I first purchased this land, and therefore my right of way is on the shared, it's a right of way in common with the subdivision owners. So subdivisions have rights of way in common. All of us share that. No one person owns it. No one can claim that land. So that's been happening a lot up our way, and some lawyers went with that, but actually Maine law says if a road is not developed in 20 years, which happened in 2005, and actually all of this information, Attorney Perkins, is in the record. The one piece of evidence in the record 3, if not 4 times, is John Cunningham's letter. He said in 2005, nothing happened, this road wasn't built, the land goes 25 feet to the center line to the abutters. So the Losies and I share this land under the right of way. All of the Sunset Acres subdivision owners in that pink area share the right of way in common. They can all walk on that road, they can use it, but it doesn't go away. My back road is cleanly on my property. And I'll pass this around. This is a survey also that the Losies did. They've been checking this out for a long time. This is an old survey. My back 25 feet is cleanly on my land, and this survey shows that. So it's a really good survey. All of these have been entered in the record. We reference them all in our brief by page. That's all I have to say. Any questions?
Can I take just 1 minute of your time? I think we still have it. What is not in the record is a deed that shows that Mr. Losi and Joan, that they own that 50-foot strip. They do not have a deed for that. And that is the most important thing that is not in the record.
So that was this. And that is a right of way in common among all of the Sunset Acres subdivision owners. So our rights do not go away going forward. So.
All right, Mr. Kelly?
So just a couple of clarification points, if I may. I beg to differ with my brother, David, in terms of view of the record. There are deeds in the record. There's a wonderful multi-page letter from the Congdons. I don't have the date memorized, that has multiple deeds attached to it and references the issues. I think David is confused when he talks about the Shays lot. So that, as the record demonstrates, the Shays lot
It's not
was
confusing.
between the end of the Sunset Acres subdivision and the Joan Corby lot. Part of the confusion is the Shays lot was also referenced as the Carl Corby lot, not to be confused with the Joan Corby lot, which is down here. It's most of, well, it's all of lot 4 as depicted on this. There is, of course, a full-size subdivision plan that was signed by the planning board. So that deed to the Losseys is in the record. When he talks about the easements, and the easements in question run from lot 7, which would have been the end of the, as you have in your materials. This is a little chewy, but it's an important point. You have that presented to you. So the easement runs from lot 7, which was the end of the old subdivision road, out to serve lots 5 and 6. That's what David is talking about. There's no easement to get past the Corby lot, which was here, the Frank Corby lot, and the Shays lot, which was here, to get to this part down here, which is this, which was the Joan Corby lot. Now, that's a little confusing, but that's in the record. The deed into the Losseys clearly does not describe it running all the way out to the main road. What is important and instructive is in the record as well, also I believe submitted by the Congress, is a clarifying or corrective deed that was issued by Todd and Robin Ann Congdon and the Dexters to the Losseys in 2023. And it had to do with access over the Trim Lane. And as the deed, which is in the record, specifically says, it served to clarify access to the Alice Shays lot, so-called, as previously described in the Wellgate County Registry of Deeds, book 1189, page 227, and which is depicted on the aforementioned subdivision plan as the Carl Corby lot. The Alice Shays lot, so-called, should not be confused with the Joan Corby lot, so-called, as described in deed to the grantees herein recorded in book 1129, page 226, which has no right of access over the road segment retained by the grantors herein. That's the 100-foot section, has no right of access over the road segment retained by the grantors herein. That was expressly put in this corrective deed to make clear that the access did not run down to the Joan Corby lot. This deed was accepted by the Losseys. It is now a record. It's also in your records in the registry, and it's here. So I want to clarify that point. My last thought is this, which is, think of all the things in my materials which David did not address. They remain before you unaddressed as problems with the approval of the planning. Thank you.
All right. We are now open to 3-minute questions, comments. Oh. We get 5? Yes.
I think 5 seconds.
Yeah, well, whatever. We'll give you 5.
The deed you just referred to was a deed done by the Dexters and recorded by the Dexters, and it said, it comes in a context where they had claimed some land that they didn't own, so it doesn't prove that we don't have easements on this side. I mean, it's kind of a self-serving statement.
All right, we have time now for questions and comments from the public. Those are limited to 3 minutes. And if you're on Zoom, put your hand in the air and we will call up. I see one hand. Is that Todd? Gary?
Yes.
So Todd, you need to unmute yourself, it looks like, and then you're good to go. Unmute. Unmute.
I see that Carrie muted me, and I thought I was unmuted. Thank you. Thank you, Carrie, for muting me previously.
Voice coming from your microphone.
Yeah, sorry. Apparently, Mr. Perkins didn't read the complete record because, as Mr. Kelly said, yeah, we did have plenty of deeds to support our position that there's no access to the Corby lot. We weren't just waving our hands. The planning board went to the 4-lot versus the 3-lot plan because there were 4 lots. You can't say, the planning board recognized that you can't say, oh, this is a 3-lot subdivision when there's actually a 4th lot on the land. So that they didn't recommend that they didn't think it was a good idea to solve the whole problem. They just said, this is what you're applying for, so apply for it honestly. It's a 4-lot subdivision. The problems with the access to the old Corby lot are have been there from the beginning. I have outlined my or Robin's and my objections to this whole subdivision in 2 letters, and I'm not going to go into them now, but I hope that those 2 letters are entered into the record too, because it outlines all of our objections. So thank you very much.
Anyone else?
Can I say something on behalf of the planning board? It's Kristen Collins.
Sure, Kristen.
Right. I have to
3 minutes.
justify my presence here. I usually don't take a position one way or the other when I'm here representing the planning board to the Board of Appeals. You're also a town board amply qualified to figure out what happened here and if anything was done improperly. But I do like to advocate for the planning board process and make sure that we don't end up with precedent that puts a lot more burden on the planning board going forward in applications like this. And so what I want to talk about is just, what we're hearing tonight is basically a courtroom litigation of the quality of title under various legal documents, which neither the planning board nor this board is qualified to figure out, especially not in the context of a, non-courtroom setting without rules of evidence and everything else. And so the law, respects that. And what the law looks for when you're looking at the threshold issue of right, title, and interest is, have you presented a document that on its face contains the rights that you need to do your project? And we did have a deed on its face here that contained the rights, at the very least, to access the lots as finally proposed. And that is really all that's necessary, because anything beyond that, again, requires us to litigate this case, which is not appropriate. So the other thing I wanted to explain is just how the planning board did receive and respond to this issue of whether the easement stretched to the Corby lot. And at the end, and it was on my recommendation, if it didn't matter to Mr. Losi, it made sense to just combine those 2 lots, 3 and 4, into one single lot 3. because there is access to at least some portion of that lot. And so what we're left now is a private question between the abutters here about whether, does that mean that because you can access only a portion of lot 3, that you can't access any of it? Or, have they overburdened the easement, whatever it might be? We actually don't know where a home ultimately is going to go on this lot, if at all. And if it's on the portion that, there's no issue about whether this easement stretched to it, then there's no issue at all. So again, it's just outside of the realm of what the planning board would do. Then the other thing I want to touch on is the findings of fact. Whether they're deficient or not, they're not deficient certainly on any of the issues that have been raised in substance here tonight, because they do go into some great detail about these title issues and why the planning board found that access was there. And beyond that, I'm not hearing any specific deficiencies that could have been, more sussed out with better, more detailed findings. Certainly not ones that were raised in front of the planning board, as far as I know. So, you might think that the findings are scant, but as to these issues that we're talking about tonight, there's plenty there. So that's all I have to say about that. Thank you.
I think you've had your time.
Wondering if I can ask a question of Attorney Collins.
Go ahead.
Yes. Attorney Collins, can she hear me?
Yeah,
Again.
Yeah.
camera's here.
Okay, it's hard to. Is there a reason a title search was not required with so many abutter questions about title and the title never having been shown, especially to our 50-foot rights of way in common?
Yeah, again, because there was a deed which described access that meets the standard for right title and interest as a prima facie matter, which is all that you have to do. And to require a title search, I think, suggests that there's going to have to be, what you're thinking about is the title opinion, not just a title search. But to require a title opinion suggests that the planning board is now going to evaluate legal claims, which, again, we do not do.
I believe the ordinance says the title search would be done by a lawyer, but the planning board may require it. And I don't understand still why the title search and what you are saying with the legal opinion, why was that not required?
I'll let the chair speak, maybe if he has anything else to say on that, but I think it's also sort of relevant here that there were lawyers' letters in the record, and the applicant is an attorney himself.
What the planning board did, whether they required something or didn't require something, is irrelevant right now. We're working with what the planning board issued and whether that met the requirements of their ordinance. So whether you wanted a title search, in a perfect world, maybe you could have gotten a title search, but there is no title search, so we need to work with what we have on the table right now. All right, any other questions from the floor?
I have
With
a hand
that, anybody else?
I have a hand raised.
Oh, sorry, it's a very small little yellow hands. Go ahead.
I would just like to point out that the deed from Joan Corby to David Losey and Joan Losey contains absolutely no wording for a right of way to that Joan Corby lot. David is a lawyer. He bought that land. It had no right of way in it. There's nothing in the deed that says anything about a right of way. Thank you.
Thanks. All right. I don't see any other little hands. We're going to close the public part of this meeting. We'll do that. And the appeals board is going to now deliberate based on what we've heard. And you guys don't get to talk. So it's up to us now. Does anyone have any questions? And I've gone through this pretty carefully, and as most of you know, I know my deeds, so, it may be able to help with that if.
Well, the issue about access of that lot is certainly the pivotal issue. And I guess it doesn't really matter to us. It seems as if someone could own a piece of property south of that, meld it with one of these lots and have even further access to Trim Lane. But I don't think that that's, even though that seems nonsensical to me, I think that's not grounds for us to accept the appeal. But I'd like to hear some of your other, opinions about this too, particularly you, Patrick, you know about things like this.
So the interest, I mean, historically. Sorry.
You said it was between you folks.
I know, but I know if I just have my back to everybody, it's going to be nasty. Oh, let's use this one, yeah. That's why these are so light, is that they don't hurt people when they fall down. All right, yeah, let's put this one up, and we'll put it up. Oh, man,
So this is the signed version here.
this is the final version,
3-lot map.
right? When what's known as the ABC company, which is Ray Ellis, Doug Grinnell, and Yaton Randland, bought the old Trim Farm and created, they bought more than what became Sunset Acres.
Mhm.
They bought what is the Losey's Lot 2 and the northern portion of Lot 3. So they had a larger area, and then they sold off some of it to the Corbys and then subdivided the rest into Sunset Acres. The deeds are pretty clear that the ABC company, this road that came down along the west side of between lot 7 and lot 5 and 6, comes down to the south end of lot 7. And the ABC company was there selling stuff down here, says we will provide a 50-foot right of way to the end of your parcel that connects and give you right back out to Marshall Cove Road, which to me means that they have right of way down into lot 3. Now, this whole question of whether it's lot 3 or whether it's lot 3 and 4, we're looking at lot 3. That's what's on the subdivision plan. This was always a different, that's part of an old Pendleton farm. And I think I know what happened up here, but it's not really relevant.
So has that substantially altered the Sunset Acre subdivision such that all members should have been part of that deliberation?
So in 67, ABC company, I love that instead of having to give their name, sold 21 acres to Carl and Joan Corbin. And that's the southern end of it. And the language in that deed said it conveys a right of way from the lot to the town road, over the road as it now exists to the point where the said existing road now terminates. Thence continuing from the termination of said road to the above conveyed premises. And what that means. So the road they're talking about, the existing road, is this 50-foot road that runs down between 5, 6, and 7.
And when they're talking about town road there, they're really
I
talking,
think it's unclear whether they're talking, whether they're thinking Marshall Cove Road
Right.
is a real road,
It
is a
sounds like
town
they're
road,
talking
or
about
whether they're
Marshall
going out
Cove.
to the town road.
And they were erroneously calling it a town road.
Yeah, but what they're saying is we will build you a 50-foot right of way into this area that will provide you with access out. Nobody's saying anything about this down here. So to my mind, that language, that conveys a right of way into the northern end of what's now labeled as Lot 3. Which provides Lot 3, if you're not trying to subdivide Lot 3 into 3A and 3B and, you know. It has access. And it's, and, you know, the right of way is within the lot. Because that's the way ABC Company laid it out when they created the original, when they were first laying things out. I mean, there's a lot of this, there's a lot of this when you go back into the 60s and the 70s here, so it's goofy because it's four guys sitting around the table figuring out how they're going to divvy up this big piece of land.
I can accept that aspect about access to the larger lot. Pins on access to the smaller parent lot, and our lawyer says that's, as you have stated, that that's sufficient.
And if you think about it, you know, think about some 100-acre parcel on the island that has access to the road. You can drive lots, you can make, you know, driveways and dirt roads back in through there till the cows come home, and then you still have access through those to your town road access. I mean, the other thing is that all these are private roads. And what really needed to happen was there needed to be a road association.
Yeah.
But editorial comment, sorry.
And the issue of frontage on a road,
The ordinance says you have to have 200 feet of frontage
Yes,
and
150 feet of water.
and they have along that north section of Lot 3, if that 50-foot right of way, the ABC, and it carries through the deeds, it's not terminated. If that exists in 67, it still exists now. And that's gotta be 500 feet of frontage.
Okay, I'm not prepared to vote on this tonight. I think I need to really mull over what was presented, and I would like us to be able to then convene another day, and I'd like to ask some questions of Patrick Lyons.
Patrick Lyons, can you come on and let us know whether we can do that?
Hi, good evening. Yes, Patrick Lyons, I'm the attorney for the Board of Appeals. Just to clarify, Attorney Collins was the attorney representing the planning board. So I'm the Board of Appeals attorney. So it's up to the discretion of the chair how they'd like to proceed. But the way the procedure goes is that the public meeting portion of tonight is closed. So now this is the time for the Board of Appeals to deliberate. And so I'm here, I'm happy to ask questions or answer any questions I can. And so whether or not you need, I mean, I guess the question for the chair and then the Board of Appeals is, do you need to table this and have a separate meeting to just answer questions or ask questions, or can you do it here tonight? So it's really, if you have questions, I can answer them as best I can here tonight. But it's really up to the chair and, you know, the Board of Appeals, whether or not you want to have a second meeting or try to get it all done here tonight.
I rechecked with the handbook for the appeals board in the state of Maine, And it said that you should not feel rushed to make a decision. And I think in this case, there's so much complexity and quite frankly, confusion about which deed and which map does what, that I think it is behooves us on the appeal board to mull it over some more, get some more information if we need it. Because this is quite a handful. It certainly took the board itself, the planning board, a long time to deal with this. And I'm not comfortable making a decision tonight just based on hour and a half, 2 hours.
So Patrick, if we table this, do we then have to schedule another public hearing, public meeting?
No. So the public, again, you could if you wanted to, but you already provided ample opportunity for all the applicant and the appellants to submit written arguments based on a record that is closed. So I just want to clarify for the board here. No new evidence can be presented to you. All that you can consider, the universe of information you can consider in making your decision is confined to the record materials that were submitted, provided by the planning board. No parties have raised any objections to the scope of that record. So that's the record here. And then the arguments that were raised by the parties, both in their written briefs that were submitted and then the oral argument that was provided here tonight. So you have the entire universe of information now has been presented to you. So the question is how do you want to proceed now to deliberate? And just a few things. And one other thing is I want to remind the board, but the standard of review that you apply here tonight, or potentially another night, is that the board may reverse the decision of the planning board only upon a finding that the decision was contrary to the specific provisions of the ordinance or contrary to the facts presented to the planning board. So that you have a narrower scope of review than like the planning board did. They had to go through, they found the facts, they had to go through all the standards that they understood to be applicable to the planning board application. Your job here tonight is to say you can only overturn or reverse their decision if you find that their decision was contrary to any specific provisions of the ordinance or contrary to any of the facts that were presented to them. So I think that what you as a board are here to do tonight is, where did you hear or read anything that you believe to be contrary to the provisions of the ordinance? Or did you read or hear any of the facts that were found to be in the planning board's decision that would be contrary to that, along the lines of, hey, that planning board said X in their decision, but the facts say Y, for an example. So that's, it's a narrower scope, and, you can go about it in any number of ways. You can just have this conversation has anything been presented to us that that invokes that authority of us to reverse this decision? Or if you wanted to, you could walk through the arguments that were raised by the appellants in their submissions one by one and say, did we find any of these, does any of this provide enough evidence or argument to say they were contrary, that the planning board got it wrong, and that their decision was contrary to the facts or the provisions of the ordinance? So that's a long way of saying it's up to you how you want to go about it. And you can go. And one other thing I want to remind the Board of Appeals is your decision. If either party appeals your decision to the Superior Court, that would be the next step. It's actually not your decision that they'll review; it's the planning board's decision. So, as far as you have, I would say that you have a full record that's before you. You've had, a number of weeks to review the record, to review the written arguments, and to review the oral, and then now you have the oral arguments tonight. You can discuss what you've heard and then come to a conclusion that either yes or no, we believe that, that the findings were contrary to the ordinance or the facts. If you, for anything that you say yes, if you were to say yes, you'd want to make that clear in your decision, what specifically yes to, and say planning board, here's how you got it wrong, and, thus, and then, find that they need to, should be reversed or remanded. If you say no to everything, you don't, you can just say, having reviewed all the evidence, we find that there's nothing contrary to the specific provisions of the ordinance or contrary to the facts presented to the planning board. And that would be your decision. And then in that instance, the appellants could decide whether or not to appeal that further to the Superior Court. So that's another long way of saying we don't necessarily have to go through. My advice is, if that were the case, you don't have to go through a long process saying everything. You've already heard all this, so now you can make this decision whether or not you think there are any contrary provisions to the ordinance or the facts that the planning board got wrong.
I have a suggestion.
Yes.
I suggest that we get copies of the minutes from tonight's meeting, because to go over the different arguments that were made by the various parties, and then meet to discuss further. But I this is too much, too fast, working through those 300.5 pages of the record without having someone to ask questions of about all the legal aspects. I don't think we should rush it. I really don't. As much as I'd like to get home and take a bubble bath, too bad. If we have to stay here, we will, but I don't see a reason to try to sew this up tonight.
So Tom and Peter and John Kerr, what do you guys think? I'm going for the Quaker consensus.
Okay,
solution.
Peter, Patrick, can you hear me? This is
Yeah.
John. I feel like I've spent a lot of time reading over these documents. There certainly was a lot of information here. Listening to the presentation tonight, I would like, my vote would be to deliberate between the board, the planning board, the Board of Appeals, and come up with an answer tonight. I can share what my feeling is, if that's okay, but that's,
Sure.
well, I listen after certainly spending a real lot of time on this, feeling like I'm certainly not a legal expert in any ways on this. I do not feel the planning board acted in error. And I do feel that the whole problem was, if you had a road association that evolved with the actual development of this property over time, you wouldn't be here where you are now. And that's my feeling, that the planning board did not err with anything negative, and that a road association that would have stayed intact over the entire development of this piece of land would have been able to deal with this without coming to where we are now. So that's where I'm at.
I'm not sure that's relevant to the case that we have now, because there isn't a road association. So we have to deal with what the actual reality was in the past and the reality
So
now.
the reality is that I feel the planning board acted in good faith.
Yeah, no, I'm not questioning any good faith, but our job is to say whether we think that whether they made any errors. I'm not saying it's out of bad faith.
Okay, I'm saying that I don't think they made any errors then. That's my vote.
Somebody said something tonight that was interesting, and there's this deed from Congdon and Dexter to Losi that deals with the north section of Trim Lane that actually abuts what's lot 4 out of Sunset Acres and lot 7. And that doesn't provide any access down to the. I'm gonna mix this up because I always mix it up. No rights to the Chase lot. But again. The deed specifically provides access to everybody within Sunset Acres. And to my mind, the way I read the language in the deeds about ABC Company extending the road south of lot 7, it provides access that way into the existing lot 3, this proposed lot 3. So there was some talk about, oh, there's this choke point and there's no access up to Marshall Cove Road. I don't think that's. If lot 3 is what is drawn as lot 3, it clearly seems to have access to Marshall Cove Road. From my perspective. I mean, we could go over this and wait. I feel sort of like John that I'm prepared to make a decision tonight.
I have a couple of other questions.
Sure.
Just as you were referencing, in the Dexter appeal, he references Losey's deed, book 4918, page 285, to their part of Trim Lane, specifically denies Trim Lane access to the Joan Corby lot. And that's still unclear to me which piece with that denies access to.
So they're saying that it denies access to this southern section of lot 3.
Right. So the other part of lot 3 clearly has access.
I think this section, the way I read the deeds, this section clearly has access because of what ABC said about extending it down into there.
And the planning board's lawyer tells us if lot 3 has access, the extended lot 3 has access.
That's what they're saying.
Okay, I accept that.
Yeah.
I still have questions, in the basic application, in item 15, it says describe the effect the activity will have on traffic in the neighborhood of the activity, and the response was none. And is that realistic? I understand that we are still working with 3 lots when there were 3 lots. We're talking about a tremendous amount of acreage, is it, maybe I should be asking the lawyer this, is that issue about usage appropriately deferred until there is a building application?
So I think on that question in general, right, the planning board chose to defer a number of either not defer, but find not applicable because the called the limited scope of this subdivision, as I understand it, is they're not proposing to develop anything. They're just proposing to split the lots. The applicants in their reply brief noted a number of provisions in the ordinance that allows them to just, that they serve the planning board, gives the planning board the discretion to waive or find not applicable certain standards. So to that or other, to the other standards, I think it's whether or not, again, I'm going to bring you back to the standard of review is your determination is whether that the planning board's decision, to waive some of these requirements or find them not applicable was contrary to the language of the ordinance. So, in reviewing the ordinance, as the applicants assert, they say the ordinance provides the planning board authority to do that. So the question you have is, was the planning board, was the planning board's action contrary to what the ordinance says? And that right for, that waiver right.
Follow what Tommy was asking, because the division is being done, and I understand it had been 3 lots and there was 1 lot, all these shapes of that property. But the dividing of the land isn't so much the issue to me, but the question of what will happen because these lots have all been tested, but to prepare them for selling, I presume, and building. Will there be problems down the line because of the issues that have been raised by some of the people who are objecting to this? And that's a question because well, I mean, is this just gonna be a real legal mess potentially in the future for people who buy the property and want a development? Want to develop it in ways that will put more burden on it? I mean, I understand like the letter of the provisions in, what we have to look at, but then is this just delaying a bigger mess later on?
I'll just say to that question, from what I reviewed, it appears that the planning board's determination was if anyone wants to, develop these lots to build a home or otherwise, they have to come back to the town and satisfy any applicable standards. So it's not a matter of, from the planning board's perspective, it was a matter of these standards will apply when they're applicable. Right now, they're not applicable because they're not seeking to develop anything. They're just dividing these lots. In the future, if someone comes back and says, okay, now I want to build a single family home, then they say, okay, do you satisfy this, the requirements of our ordinances to build a single family home? And that's when they potentially would, review these standards that they determined were not applicable now. And your responsibility was that decision contrary to the language of the ordinance? So you would want to review.
They have a question about this with all these, either you just talking about, no, the right of way exists. And I mean, that just seems like another kettle of worms. It's not really the way it's supposed to be said, but if this is still an issue because it really hasn't been resolved in exactly where somebody's property is.
Yeah, so that issue, this issue of the easements and the right title and interest, that is not, and I agree with the planning board's attorney, like that is not in your purview of a board of appeals to determine these rights. The right title and interest is a threshold issue that's designed to, kind of be the first question you would ask, or one of the first questions a planning board would ask, do you even have the right to do this? But it's not designed to be a process where then the planning board goes through a legal analysis. It's supposed to just be, hey, can you give us a prima facie, some kind of showing us that this is enough. And by and the planning board's determination was they provided us deeds. These deeds note certain, easement access rights. It's in the record, your chair has been discussing it. So again, that it's not a high bar. It's not supposed to be something, if there's, questions of whether or not what's the scope of this easement, that's not your job to figure out. Your job is just like, hey, did they give us something that shows us that they, have the right to get onto this property? And the planning board said, yes, the deeds they provided were sufficient. Your job as the Board of Appeals was to say, okay, do we think, were they wrong? Was there evidence in the record contrary to their findings? So the question is there any evidence that is, contrary to that decision? There's been assertions from both parties from the applicant saying they didn't assert anything showing otherwise. And then you have arguments from the appellant saying, well, there is something there. So again, from what I've heard from thus far in the board's deliberation, is the board thinks that they did the planning board was correct in satisfying that they satisfied the RTI requirement.
I have one other question.
Sure.
My other one is about, whether this has, had substantial changes to Sunset Acres, since we're talking about a right of way that was all about a right of way provided in the Sunset Acres subdivision. Should the other members of the Sunset Acres been part of this deliberation? And they certainly weren't. And this is a procedural thing that the planning board, it's responsibility to do that correctly. And it seems to me that this has implications for the Sunset Acres subdivisions, certainly because of this road of access, Trem Lane, and that other people should have been involved in this process.
So, sorry, I guess I didn't understand. What's your question in that? Should the planning board had sought out input from the other subdivision members?
Yes, that's my question. That seems to me reasonable and described in the land use ordinance.
Where is it described in the land use ordinance? I'm just asking because, I just want to make sure we're on the same page.
Not sure.
I'll find out. What's happening there?
None of the general provisions about subdivisions, or any kind of, I don't know.
Will not cause any unreasonable public or private road congestion or unsafe.
Again, without being able to review the specific provision in the ordinance, I can't speak beyond that. But what I did hear tonight, is, as I understood it, is the applicant was saying, the lots, no lot in the original Sunset Acres subdivision has really been changed substantively. There's, the lots already existed, and the only difference is now this larger lot 3. But because that wasn't part of, as I understood it, their argument is because that wasn't part of the Sunset Acres subdivision, it's not relevant to, it's not a change to that subdivision. In essence, the lots that were part of the subdivision remain, the same lots, and then there's this additional lot south of that wasn't part of the subdivision, but it's not a change to the Sunset Acres subdivision. I think that's what the argument was raised by the applicants. And again, you go back to the planning board's decision and your standard of review here, and is whether there's anything contrary. You can only overturn the planning board's decision if you find that their decision was in some way contrary to the ordinance. So unless you can point to something in the ordinance that says it was contrary, that's why I'm asking, where specifically do you believe this is contrary?
That wasn't referenced in any of the appeals, I guess.
Well, then, and that's another question. If it wasn't referenced in the appeals, then it's, in essence, it was that they would have waived the right to raise that argument here tonight, right? If it wasn't, if they didn't brief it, if they didn't raise it, and now they're raising it for the first time tonight, whether they actually preserve that argument for this board's consideration is that question as well. But again, you have to be able to point to the ordinance and say, planning board got it wrong. Here's what it says.
Can you check the record, please? We brought it up.
So yeah, if they brought it up, then it's preserved. But again, it's their burden to convince you that the planning board got it wrong. And so where in the ordinance does it say, that question, where did, did they fail to meet that requirement? So,
I mean-
and I'll just add this here for the chair's consideration. If the board isn't prepared to rule on this tonight, that's fine. It's your discretion. One thing you could then ask is that the parties submit to you, the board, propose findings and conclusions. We did provide that option to the parties, and they didn't take the board up on it. Oftentimes a proposed finding and conclusion, basically you draft the decision you think we should author, can help the board kind of understand exactly what these arguments are, where in the ordinance they either say it supports or doesn't support the planning board's decision, and that's why we should come to a conclusion. So if the board's prepared tonight to make a decision, go right ahead. But if you're going to defer to another night, I would suggest that you invite the parties to submit something like that, because that could help your deliberation at that subsequent meeting.
And that would be a statement where they're focusing on some particular aspect that we brought up.
Their
for
findings,
consideration
what
tonight.
they would suggest as a result.
Because you as a board are going to, after you come to a decision, you need to issue a written decision. Basically we're saying, hey, why don't you give us what you think we should issue as a written decision? You don't have to adopt any of them, or you can, use parts from other ones, but I've found in practice that's, the parties are closer to this than anyone. They can provide those proposals, and that can help the board, review this information, and, come to a decision in this next meeting.
That's what the applicant has already done, has given us a written rebuttal of each of the points of the appellants.
They gave a rebuttal, but it's different. It's not, they said, here's why we disagree with some of the things that the appellants have said, but they didn't actually say, here's how we think your decision should look. And that's, again, they've already made all these arguments, but you're basically asking them, okay, you made all these arguments. We're trying to wrap our head around all of this. How do you think we should rule? And both sides get to do that. And it can be a really helpful exercise for them, the board to review the different proposed findings and help you get to a point. Because what we're asking for is, hey, there's 300 pages or so of a record, 367 pages. You have, multiple ordinances that apply. Tell us what facts in that record apply to what provisions of the ordinance that either support or don't support the planning board's conclusion. Because that's really what you're doing, need to do here tonight, or at a subsequent meeting.
And that would be more concise than what we have in the record now, as far as the applicant's rebuttal to the appellants.
I think so. I think it would help you wrap your head around all this. I'm not gonna, I reviewed this and I can understand why this is a little difficult for the board to process through, because there's a number of arguments raised that touch on any number of aspects of the application and the planning board's decision, but there's no, it's a little scattershot. And we'd ask for, hey, why don't you give us, here's a more narrowed target here for you to kind of help us figure this out.
So Peter, I saw you nodding your head at that. Would that be helpful?
Yes, it would be. Yeah, I think it would be.
Okay. So can I get a motion that we request the applicant and the appellants to do this?
I so move.
and that we give them a week?
Week,
A week?
is that reasonable?
Yeah, it'll be gone 3 days of next week, so maybe 10 days.
10 days?
was
Do I
gonna
hear
say, how
10
about one
days?
day? One day.
It's not gonna happen in one day.
We gotta get this over with. Come on, you guys. It's like been a long year.
Well, it's very, very complicated.
Yeah.
Um,
So
You could propose a deadline of the 11th. That's Friday of next week. That's, I think, in essence,
That sounds
today.
good.
And then you would just need to schedule
we will schedule a
Potentially
meeting.
the week of the 14th.
Is that cool? Okay, so we have a motion.
yes, I so move.
A second.
Okay, we have to call the roll here. So John Kerr. You cool with that?
I am cool with that. Yes.
Okay, Peter,
Yes.
Tom,
Yeah.
Susan, I'll say yes. All right. That is what we are going to do. We are going to defer this. We are going to request findings or proposed solutions from everybody. We want those on April 11th. And then the Board of Appeals will get together, review those, and issue a decision.
Thank you.
Is that right? All right. Can I get a motion to adjourn?
So moved.
Second.
All in favor? We're done.
And just, Patrick, I would say the parties can all submit their proposed findings if they choose to provide them the same way they did everything else to the the share file. And that
Yeah,
way we can get it to
great.
everyone. And then when you get a chance, Patrick, let's just, reach back out to me about scheduling, what date works for the board and all that, once you
Okay.
guys figure it out.